2020-75, State of Arkansas versus Mark Anthony Lewis. All right, Mr. Lewis, in case 2075, you're for arraignment today on charges of possession of drug paraphernalia, Class D felony. The second count of possession of paraphernalia, D felony. A third count of possession of paraphernalia, and then a fourth count of possession of paraphernalia. This one's a Class B felony. Actually, there's two of those Class B felony charges, and then obstructing governmental operations, a Class A misdemeanor. On those six charges, how's the defendant now plead?
Not guilty, Your Honor.
The court is entering a scheduling order that sets this matter down for hearing, for trial, the week of August 17th, and final hearing on the Thursday before that, August 13th. Mr. Cooper has been appointed in the case.
Yes, I understand, but
Sir, Mr. Cooper, could I speak?
Yes, go ahead.
I was under the impression that I'd be coming over there today to, was that not what we discussed?
Your Honor, what he is talking about is he had talked to me about the possibility of drug court or going to John 3:16. I discussed with Nick Mayfield yesterday, who may or may not have been over there to see him yet, but now I've been informed by Mr. Etheridge that drug court is on hold, pending, I guess, who is going to be the judge after you retire for drug court. So that is not an issue we can address today, Mr. Lewis. Mr. Lewis, on John 3:16, I approached Mr. Etheridge about that, and he will not agree to that. So, Your Honor, there would be no further action on Mr. Lewis's cases today, but he's exactly right. We did talk about those two issues at the jail.
Your Honor, regardless of the status of drug court or John 3:16, the state is not going to allow Mr. Lewis to go into either one of those programs.
All right. Well, I mean, with regard to the status of drug court, I'll just say here on the record, I have been assured that once I retire, one of two of the circuit judges will become the drug court judge, and will continue drug court into the future. So we will have drug court. That's not a reason to not put somebody in drug court now. There will be a drug court going into the future. Whoever takes it over may vary some of the rules of the way we operate it, but that's his prerogative, his or her prerogative. So we'll have a drug court, but as I said, the thing I wanted to check on was also we have for Mr. Lewis, we have 2019-52 and 2019-396, two revocation cases. Let me look at those as well.
Mark, have you seen Mr. Mayfield yet?
No, sir, I have not.
Yeah, Mr. Cooper, I appreciate that, but again, the state is not going to allow Mr. Lewis to go into drug court. That's not an offer we're making. We're anticipating revoking him and putting him in the Arkansas Department of Corrections.
My records before me reflect in the cases 2019-52 and 2019-396 that Mr. Lewis was down for a revocation hearing today.
Your Honor, that's what we reflect also. Your Honor, I'd like to continue that until March 19 in light of the new charges that are filed, and I'll get back over to the jail and visit with Mr. Lewis. Obviously, we'd like to conclude everything, including the new case, along the revos.
All right. March 19th, the court is moving the hearing on that to March 19th. I'm going to reflect that's on the defense motion.
Yes, Your Honor.
All right.
60 days is waived if it hasn't been already.
All right. So, Mr. Lewis, your situation is you remain facing two petitions to revoke in two cases. I believe I looked it up that you were arraigned on those previously. Let me make sure. Yes, you were. Yes, on February 6th, you entered a plea of not true on those, and they're set down for at this time for hearing on March 19th. Your attorney will be over to see you. You may be excused at this time.
Thank you, Your Honor.
Two 2016-38, 2020-34, 2020-90, State of Arkansas versus Vanessa Henschel. Ms. Henschel, you're back before the court on three separate cases. One is 2016-38. We'll check on the status of that. On that case, you were in front of the court on February 6th. You refused to talk. The court entered a plea of not true in the record. Your defense counsel, Mr. Cooper, was appointed, and Mr. Cooper reported on that day, and again checked today. Apparently he's been down to see you in the jail, and you're not talking to him. Is there a reason why you're not talking to him? Can you hear me?
We can hear you, Your Honor.
All right. So, Ms. Henschel, you're choosing not to talk. Is that correct? All right. I'm going to take it as such until you indicate in some manner that that's not your wish. So I'm advising you that we took a plea of not true at that time. This matter was set down for revocation hearing today. Mr. Cooper is where's things? I know you told me earlier that she wouldn't talk to you when you went to the jail and went into her cell and tried to talk to her, and she wouldn't speak to you. Is that correct?
We've had no communication whatsoever, and as I also informed the court, it's my intention. I understand there's about to be another charge filed, and when that charge is filed in both the new charge, or new case, and in this case, I intend on asking for a psychological evaluation of Ms. Henschel.
Right.
You know, the state understands fully why Mr. Cooper is having to do that. The state, however, would like that to happen as soon as possible. We are, I will say, in the state position, we believe that the safety of our citizens are at risk from Ms. Henschel's moments out.
I think the new charge has already been filed. I think we're to arraign her on that charge today, which is 03 CR 20-90.
She's not filled out an application. I think before she refused to fill out an application. I talked to her about that at the jail, and again, I've received no acknowledgement from her. I'm assuming that she's not filled out an application. If she has, we don't have it. If we're being appointed, then we would enter a plea of not guilty.
The charges in this case are battery in the second degree and impairing operation of a vital public facility with damage to property or to an operator. Those are a Class D felony and a Class A misdemeanor, and it's my understanding that that has to do, through a view of the information, that has to do with, on the 24th day of February 2020, the Miss Henschel, without explanation, words, or any reason, struck a jailer who was attempting to assist her in moving from, I believe it was the shower, to a cell, and caused injury to that jailer. So that's the allegation in this case. On those charges, Ms. Henschel, I'm going to appoint the Public Defender's Office in the person of Mr. Cooper, who's represented you in the past and is currently representing you on other matters. Appointed him at this time, unless you can tell me that you know of some other attorney that you would like to either to hire or have appointed. Are you requesting a different attorney for any reason? Someone you would actually talk to? Getting no response whatsoever. So, Mr. Cooper, you'll be appointed in this case. I'm going to enter having read over the charges in this case, I'm entering a plea of not guilty in case 2090. Court is aware also that Ms. Henschel has another case pending, which is case 2034. Let's check on the status of that case. Court is aware also that Ms. Henschel has another case pending, which is case 2034. Let's check on the status of that case. The charges in that case are aggravated residential burglary, theft of property obtained by threat of physical injury, theft of property, a separate charge, Class A misdemeanor, battery in the third degree, aggravated assault. That's the battery in third degree is a Class A misdemeanor, aggravated assault is a Class D felony, and criminal mischief is in the first degree is damaging property. All of those allegations running through here. She appeared in front of this court on February 6th on those allegations, which are alleged to have occurred in late January of this year, and again refusing to talk. Public Defender's Office was appointed, and a plea of not guilty was entered on her behalf in those charges. That case is set for trial by scheduling order during the week of June 22nd, and final hearing on June 18th. Now, it's my understanding, Mr. Cooper, you've been appointed in all three of these cases and are representing her, and have made a good faith and diligent effort to go to the jail and see her and talk to her. That at this point you're indicating to the court your intent to file a petition for evaluation. Is that correct?
We will have that filed probably by tomorrow or Monday at the latest, Your Honor.
All right. Now, Ms. Henschel, what that means, I don't know for what reason. I know you've spoken to another judge on occasion and actually entered a plea in an earlier case. So I know you can talk. I don't know what you expect to achieve by not talking, but that's, if that's what you choose, then we'll deal with it. But I'm just advising you, you can, at this point, given the violent nature of the allegations against you and other matters, it's difficult to address issues of bond because your actions of invading other people's homes and violent actions in the past and in the very recent past, as alleged in these charges, make it difficult for the court to set any kind of bond at this point. And you won't communicate with your court-appointed attorney so that we can make any arrangements with respect to bond. So for the moment, the bonds are being left set where they are, and there apparently is going to be a petition filed to get you evaluated. In the meantime, you're going to remain in jail. And if that's what you want, then that's fine. You haven't indicated in any way that there's any basis for giving the court any basis to consider releasing you at this point. So that's where we stand. You may be excused at this time. Do we have? I'm going to go ahead at this point and call 2020-72 State of Arkansas versus Virginia Elizabeth Long. The Public Defender's Office been appointed in the case.
Yes, Your Honor, we have been.
This matter is for arraignment on charges of aggravated assault, a Class D felony, and resisting arrest, a Class A misdemeanor. On those charges, how does Mrs. Long plead?
Not guilty, Your Honor.
Plea of not guilty is noted. The court is setting this matter down by scheduling order. The trial date that's being set is the August 17th trial date with a reappearance on August 13th. That's for a final hearing. If other hearings are needed, talk to your attorney and make sure, you'll contact us and we'll.
We've already visited, Your Honor. She was in the jail, and when I made her aware that she could bond out, obviously she's done that. So
Yes, sir.
we've already had communication.
All right. That scheduling order specifically says that you're to stay in touch with your attorney. The obligation is on you, and I'm ordering you to do that. And as I've explained to other people, you've heard me.
Yes, sir.
Not doing that can result in you being held in contempt of court and put in jail. So
Yes, I understand that.
make sure you do take care of it.
I understand, sir.
All right.
But may I ask a question? Since I don't live in Arkansas, is it okay that I go in Missouri? Because that's where I live.
Your Honor, I'll let the court answer that.
I didn't know. I'm not breaking the law doing that, sir.
Are you out on bond?
I already paid my bond on full.
Are you out in bond?
Yes.
Okay. Who's your bondsman?
Ron Carley,
Okay.
here in town.
I told you.
Sorry.
Provide that information where you're going to be to him. And so if you're out on legitimately bonded out and he's good with it, you just provide where you're going to be to him so that he can know where to find you. All right?
Yes, sir. Sorry.
All right.
I'm sorry. That's
And
not
then
a
you're-
problem.
Right.
Thank
You
you.
may be excused. And then we have Kelsey Nicole Gildner here.
She is back to the case, Your Honor. She's here for plea.
All right. Case is 2017-148 is a revocation case. 2020-8.
Your Honor, this will resolve the revocation case also, Your Honor.
Okay.
Your Honor, there are, Mr. Cooper's handed to you yet the police statement that there are two misdemeanors in this that were in all process, Your Honor.
All right. Ms. Gildner, you're appearing at this time for purposes of changing your plea, is that correct?
Yes.
Yeah, the change of plea is brought about by an agreement that's been worked out for you by your attorney, Mr. Cooper. Is that correct?
Yes, sir.
Have you discussed the terms of the agreement and the punishment you're to receive with Mr. Cooper?
Yes, sir.
And do you feel you understand what the agreement is?
Yes, sir.
Are you satisfied with the advice and the representation you've had from Mr. Cooper?
Yes, sir.
On the charges as they're being amended by this agreement of possession of a controlled substance, methamphetamine, a Class C felony, possession of a controlled substance, Suboxone, a Class A misdemeanor, and possession of drug paraphernalia, a Class D felony. On those three charges, how do you now plead?
Guilty.
You're entering this plea of guilty pursuant to the agreement we made reference to. That agreement is set out in writing in the document I'm holding up called a plea statement. Have you read through and signed this plea statement?
Yes, sir.
And in going over it, do you feel you understand what's contained in the plea statement?
Yes, sir.
You then understand the nature of the charges against you and the full range of penalties you're facing?
Yes, sir.
You understand the rights that you give up or surrender by pleading guilty?
Yes, sir.
When you plead guilty, you give up your constitutional right to a jury trial. Do you understand that?
Yes, sir.
And with that right to a jury trial, you're also giving up your constitutional right to have an attorney represent you and assist you throughout that trial. You're giving up the constitutional right you have to confront witnesses that would appear and testify against you at trial, and you're giving up your constitutional right to appeal. All of those are rights that you're giving up by pleading guilty here today. Do you understand that?
Yes, sir.
So understanding what rights you're giving up, are you still willing to plead guilty?
Yes, sir.
Are you pleading guilty here today freely and voluntarily?
Yes, sir.
Has anybody in any form or fashion forced you into this plea?
No, sir.
As you plead guilty here today, are you admitting that on or about January 7th of 2020 here in Baxter County, Arkansas, on that date, I believe there was a traffic stop. On that date, you had in your possession a quantity of methamphetamine. Is that correct?
Yes, sir.
And you also had a quantity of Suboxone.
Yes, sir.
And finally, you had paraphernalia related to the use of methamphetamine.
Yes, sir.
Based on those statements, the court's going to find that the defendant has freely and voluntarily entered her plea of guilty here today, done so after consulting an attorney, and has admitted here in open court her actions that constitute the basis of these crimes. The state is, pursuant to this agreement, the state is null prosing the theft by receiving charges, the no liability insurance allegation, and the habitual offender, and the court accepts her plea on the other charges, and at this time formally finds her guilty of possession of a controlled substance, methamphetamine, Class C felony, possession of a controlled substance, Suboxone, Class A misdemeanor, and possession of drug paraphernalia, Class D felony. Having adjudged the defendant guilty on those offenses, pursuant to the agreement in this case that the parties have agreed to, the court is sentencing the defendant on the Class C felony to 8 years in the Arkansas Department of Corrections, on the D felony to 6 years in the Arkansas Department of Corrections, and on the possession of Suboxone to 1 year in the Baxter County Detention Center, or that sentence suspended. All of the sentences will run concurrent with each other, and the defendant is to pay costs of $200, a fine of $2,000, the statutory DNA fine of $250, the booking administration fee of $40, public defender fees of $200, and a drug crime assessment of $125. All of those amounts will be due and payable by the defendant upon her to the Baxter County Sheriff's Department upon her release from the Department of Corrections, with payments to be made in regular monthly installments of not less than $100 per month, beginning within 60 days of her release from incarceration. That'll be the order of the court. The defendant is remanded into the custody of the sheriff's office to await transportation to the Department of Corrections. That'll be the order of the court. You may be excused, ma'am.
Okay.
Your Honor, she has a revocation that I believe the state is.
Oh, yeah, and the revocation matter, which was 2017-148, is being dismissed by on motion of the state.
Thank you, Your Honor.
All right, you may be excused.